everybody, welcome to SEN Talks. I'm here with Matthew Wyard, who you would have seen in our last podcast where we were talking about health and deputyships and a lot of deprivation of liberty. And we are here again today talking about social care. So Matthew is a barrister at 39 Essex Chambers, and he specialises in education, health and social care. I'll let him do his introduction again for some people who skipped last podcast. So hi, Matt.
Hi, Stella. Good conversation last time. Thanks for having me back. So I'm a barrister at 39 Essex. I do a lot of education work, health work, social care work, community care. Lovely,
thank you. So what I want to discuss with you today is something actually that a lot of my parents are very anxious about, and it's more the social care side of things. So we're looking at transferring from children's social care to adult social care, right, and all of the gripes and confusion a lot of the time that brings. Yeah. First of all, what's the main thing for parents to be looking out for? Like, what should they be expecting? Because it's in year 9 that preparing for adulthood kind of comes in, and everybody starts talking about preparing for adulthood in year 9.
The annual review. Yeah. So from my perspective, the main thing is to make sure it actually happens in year 9. Yeah. Because it's all very well, the SEN Code of Practice saying preparing for adulthood conversations start when you're 13 or 14. Yeah. My experience is that actually it's kind of put on the back burner. Yeah. And the social care really starts to be thought about at 17, which is not ideal because then you're constantly playing catch up and having to push the local authority to do something.
Of course. And time that tends to run really quickly when you're that age as well.
Yeah. So I think start thinking about adulthood early. Yep. And I know we're going to come on to talk about CHC funding as well. Okay. And it applies to health and social care, whichever system your child is going to be looked after by. Start early. Start 13, 14, thinking about things.
Yeah, I think so.
Get the local authority to think about it too.
Yeah, and kind of understand what services there are in your local authority. Start going to have a look at those services. Start thinking about and asking, in fact, your child, because they are, maturing. They do have opinions, and I know from SEN Tribunal, we all know that the tribunal does place a lot of importance on young people's views. So I think maybe you start researching and looking at all of those and getting their opinion on it as well.
Yeah, and also know what you're entitled to, because it's very easy, I think. I mean, I can't speak from personal experience, but I get the impression it's very easy when you are a parent looking after a disabled child. You get so completely understandably caught up in looking after their needs then and now, and having a dispute with the local authority about education if you've got one. You forget that actually there is an end game. There is an end period where that will all stop. Yeah. It's often 25. Yeah. But it can be 18. And you need to plan early because there are things that take time that need to happen. So you need to know what you're entitled to in advance of needing to try to get it.
Yeah. So if I can give you an example to those who are listening, I had a case of a young person who was in a 52-week residential placement, and we had a Section 20 agreement signed because just to let you guys know that a Section 20 agreement is basically an agreement that you consent as a parent for the local authority, as it were, to look after your child. It's like it's a voluntary...
it's voluntary accommodation.
Yeah, voluntary accommodation. And a lot of parents do get a bit freaked out when... because your child or young person is being assessed as needing a 52-week residential placement, or they have to because the suitable placement is too far away to travel, etc. But it's usually because they need that because they struggle a lot with transitions, or there's some kind of really complex and pressing issue where they need to be in that kind of placement. And you're presented with a document, a Section 20 document that says, I'm relinquishing responsibility for my child. Like, what would your advice be generally on Section 20 agreements?
So I think you need to know what it is first. So Section 20 comes from the Children Act. Yeah. And, I mean, effectively, this is a massive summary, but basically what Section 20 says is that the local authority has to accommodate a child if various criteria are met, and it's that they don't have parents because they've died, basically.
Yeah.
Or if they're lost or abandoned, or because the person caring for them is prevented from providing them with suitable accommodation.
Yep.
So the wording of the statute is not particularly helpful because it's an automatic negative, because there's a suggestion that you can't look after or accommodate your child. But the reality is, in a lot of situations, some parents can't for whatever reason, particularly in challenging behaviour. So
it's not because they don't want to.
No, exactly. And I think that's important to bear in mind. So if you can't look after your child, you can say to the local authority, I need you to accommodate them. And the local authority will do one of two things. Either they'll issue care proceedings, which parents get very worried about, understandably and rightly so, but care proceedings will usually only be appropriate if there's harm and the young person is at risk of significant harm, which is not usually the case if your child is presenting with behavioural challenges that you then can't deal with. So what you'd say to the local authority is, can you voluntarily accommodate my child? Under Section 20 of the Children Act, the local authority will usually say yes and make you sign a Section 20 agreement. But it's voluntary.
Yes, that's important.
You need to understand that you can cancel it at any time. So if you're, and I've seen this used tactically before, so if you are wanting your child to go to a particular residential special school, you might say, we've got a place available there. We can't look after our child at home. We want him voluntarily accommodated, but we will only consent to him going to this school. Now that can backfire quite extraordinarily. You can end up in care proceedings, but Section 20 is good if you can't meet your child's accommodation needs at home. As I say, it's voluntary. The key thing that parents also need to be aware of is the concept of parental responsibility, which is ultimately a family law concept, but it's the idea that you have responsibility to look after your child and make decisions on their behalf, effectively, in practical terms.
You retain that, don't you?
Yes.
Yeah.
And that's the key distinction between care proceedings and a Section 20 agreement. So Section 20, voluntary accommodation, you retain PR, which is why it has to be by your consent where they're accommodated.
Yeah.
Because you can override it.
Yeah. I've seen really long agreements like that as well, where there's like a tick box exercise for every decision or kind of situation that could come about, like dentistry work, going to the park, going to the shop, any kind of vaccinations, for example. That's
for practical reasons, right? Because if a local authority is accommodating your child, I don't know if you live in London and they're accommodating them in Newcastle, because that's the only place that they can find to meet their needs, then they don't want to have to be constantly trying to contact you if there's a medical emergency. So you start to give consent for certain things to happen.
Yeah. What happened in that case, without revealing any information about the young people is, or the family indeed, is that when my young person came to about 15, maybe just before their 15th birthday, local authority started making noises. And they were in the 52 residential placement, quite a complex young person, started making noises about issuing care proceedings potentially, and trying to get this young person to come home when there was a Section 20 in place. And there was a lot of anxiety on behalf of my parents because, first of all, the young person's only been in the placement for 2 years and they'd just started to settle, just started to engage in learning. You know, their regulation had become better, but the learning had just started. So there was a threat of that being completely taken away. But also when you've got a local authority saying, we're going to issue proceedings against you to take your child away from you, potentially. Because that's what we hear, isn't it? We're going to take your child away from you, or your young person away from you because they're going to be 16, etc. What is it that parents need to be thinking about and looking at, or who do they need to be contacting, indeed?
I mean, in your case, because they were 15, there's a cut-off age at which point a care order can be made. So that's probably why they were thinking about it at 15, because as soon as they hit 16, it becomes much more difficult.
It definitely was. They told us that openly.
I mean, so people conflate two things, right? They conflate care orders and placement orders. So everyone's fear as a parent is having your child taken off you and you not having any rights over them, right?
Of course.
And we see things in the news about it, and high-profile cases where children have been taken into care and harmed.
Yep.
Care order is not a placement order. A placement order means that a child can be removed from a parent and then adopted out of their family. A care order does not mean that at all. All a care order does, I say all, is give a local authority overriding parental responsibility. So that means that if there's a decision to be made in relation to the child and they think a parent is going to make the wrong decision, the local authority can say, no, you can't do that. We've got overriding PR. The correct decision is this. That can often result in children being removed from families to live elsewhere. And that is one potential outcome of a care order, because what will happen in the family court, and I say this as someone who spent, well, I was a pupil and when I qualified doing care work, what will have to be in front of a family judge is a care plan saying this is what we intend to do with our PR. Parents need to know that just because a local authority asks for a care order does not mean that they're going to remove them from where you live.
Or that they're going to get the order granted.
Or they're going to get the order granted, no. And the problem from a local authority perspective in trying to get a care order in a case where Section 20 is being used is twofold. Number one is to get a care order, they have to show that a child is at risk of significant harm, which, as I mentioned earlier, is not always the case.
Mm-hmm.
But number two is local authorities don't seem to have, I don't understand why this keeps getting brought up, but local authorities do not understand that Section 20 voluntary accommodation can be a long-term care planning option. And there's a Supreme Court case where this question was looked at because there was a threat of care proceedings being issued because there'd been a long-term Section 20 agreement used. And the judges all said that's fine.
Yeah, I was going to raise that actually, because I've seen some local authorities ask for that ask for that Section 20 to be renewed annually.
Yeah.
And saying, this isn't a long-term thing. And the way that I interpreted it was that, well, it's in place until the parents just remove it or withdraw it.
And the stupid thing is most Section 20 agreements actually say that as well.
Yeah, because that's what the law specifies on it. So I'm always quite, and it doesn't make parents anxious because I've got another one and I have to renew it every year. And what is it that I have to think about? And it's like, well, I mean, and my advice usually is we'll just sign it every year because
nothing's changed.
Nothing's changed. It's just, and it will, and even if you sign it today, you can withdraw it tomorrow, regardless of whether you signed it again for 6 years in a row.
It's just for local authorities' risk management purposes,
Perhaps,
I suppose. They don't want any suggestion that, I mean, this has happened before. Any suggestion of you saying, we don't consent to it anymore, and them saying, well, actually, you have.
Yeah. It's
Here's
just
the written evidence that you've consented to.
It's a renewal, isn't it, to say that, well, they've had a look at it again.
Yeah. And I suppose it does show, as you say, actually, that the local authority are looking at it again, and it's good for them to be seen to be reviewing these things.
Yeah, and I suppose that's prudent of them, really, isn't it? Because, with the local authority, and again, I find it difficult to be fair and balanced sometimes, but I can see how local authorities fear stuff like that because of everything that comes out in the press when a mistake is made.
Yeah.
And, I don't know how common mistakes are made, but fatal mistakes are almost always reported. And so it is a good thing for local authorities to be looking at these things more frequently. I think that's just a benefit, and I hope that helps alleviate some kind of anxiety. What I also wanted to talk to you about today is CHC funding.
Okay.
Because it comes up occasionally, and our parents need to understand exactly what it is, how they can apply for it, what the assessment process is. So if you just kind of explain to our listeners what is CHC funding.
Yeah, so when you hit 18, when a young person hits 18, there are two routes that can be gone down to meet their care and support needs. The social care route, which is the route under the Care Act, or CHC. And CHC, so continuing healthcare, is effectively, for practical purposes, it's a package of care that's delivered to someone over the age of 18 by the NHS, designed to meet their care and support needs that arise from a primary health need. And that's the distinction between CHC and social care provided under the Care Act, is to be eligible for CHC funding, you have to have a primary healthcare need.
Right, so it's maybe more physical.
Yeah, it can be. I mean, it's just about distinction. So it all comes down to how severely disabled you are often. I mean, that's a really loose and overly simplified way of looking at it. But it tends to be, my experience tends to be, the more complex someone is, the more likely they are to get CHC funding.
Right. So I'm just trying to break it down. I know these are massively complex legal distinctions and medical distinctions, in fact, but is it reserved for the most serious and severe of disabilities?
No. It's just if your need for care and support arises from a health need,
it has to derive from a health need.
Then that is potentially eligible for CHC funding. I mean, the problem, and the reason it's quite tricky to define, is the process that's followed to assess whether someone has a primary health need is hugely complicated and very assessor dependent. So there is an assessment process that's followed, and it's a 2-stage assessment. So the first one is basically a filtering stage. So whether someone, again, this is not the legal definition, it's a simplified way of putting it, but whether someone definitely isn't eligible for CHC funding, they will be filtered out. If you are potentially eligible, so you may have a primary health need, you'll then put forward for a full CHC assessment, which involves an MDT, a multidisciplinary team made up of 2 people, either 2 healthcare professionals or 1 healthcare professional and a social care professional, filling out something called the Diagnostic Support Tool, which is a 36-page document that specifies, so it's broken down into 12 different domains.
Love a government form.
Yeah. So things like breathing, nutrition, mobility.
Okay.
There's 12, there's loads of them. And someone's needs are assessed in relation to those domains.
Okay.
And they can be assessed as low, moderate, severe, or for some of them a priority need. And depending on the outcome of that assessment depends on whether you have a primary health need or not.
Okay.
And basically, if you're assessed as having a primary health need, then you get CHC funding for care and support.
And that's 100% funding.
It is. So that's a big and important distinction between CHC funded care and social care. Because if you have a package of care under the Care Act, you get assessed. You have a financial assessment. It's means tested. So depending on what you earn, what your financial situation is, you may have to pay a contribution towards your social care, up to, in some situations, having to fully fund it. With CHC care, it's all funded, 100% funded.
And it's not means tested,
Not means
is my
tested.
understanding as well.
It's not.
Okay, that's interesting.
Which is obviously a massive benefit, right? Because you're having the state pay for all of your care and support.
Of course, it is one of the few things that isn't means tested these days, isn't it? So no, it's good to know. But I mean, what based on that explanation, my advice would be go for the CHC funding, right?
Yeah.
When you're looking at either or, make the application.
Yeah, you may as well.
Yeah, you may as well make the application, which I don't think a lot of our parents know about. I think so. It's a really good piece of information.
And the reality is, I mean, again, we've talked about planning in advance. The CHC guidance is pretty clear, which is that local authorities, as soon as someone hits 14, should be, so taking a step back, the public body that manages CHC packages of care is an integrated care board. It used to be called a clinical commissioning group, CCG. People may have heard of it.
Yeah,
that was replaced.
CCG.
Yeah, they're now ICBs.
I don't know why people change names like that. I'll show a side note, but I still say CCG.
Well, a lot of people do.
Yeah,
but technically it's now an ICB, integrated care board. And your local authority, when your child hits 14, if your local authority thinks they might have a primary health need, they should be telling the ICB when they're 14.
Right.
They don't, because there's no real practical impact of it. So most ICBs won't assess until someone hits 17.
Right.
But it's important to note that when they're 17, they can have an assessment for funding that would then kick in when they're 18.
Okay. So the assessments happen at 17.
They can do.
But the ICB can be informed when the child or young person is 14.
Yeah.
Okay. So that's why the planning's quite important.
Yeah.
Yeah.
Because if the ideal situation is that you say, well, when they hit 18, they need care and support.
Yep.
Local authority, you do a needs assessment under the Care Act, Section 9. Local authority does a needs assessment. You say to the ICB, can you also do a CHC assessment when they hit 17? ICB does the assessment at 17, agree that they are CHC eligible, and that funding can then kick in on their 18th birthday.
Okay.
Which means there's no gap.
So my understanding is there's like an initial checklist and then a full assessment.
Yeah,
and that's the filter bit.
So the filter is where you get a no, basically. They can't. So if you say to your ICB, assess the young person, they have to do the checklist.
Okay. Okay, that's good to know. And is there an appeal process if they say no, even at like first filter stage or full assessment stage? Can you appeal?
No, it's called a review.
Okay, fine.
So you can ask for it to be reviewed, and you can, at the full assessment stage, ask for a review as well.
Okay, what is that? Again, what does that entail? Is that a lengthy process? Is it an expensive process? Or?
No, I mean, some there was a period of time where a couple of law firms were doing it on a no-win, no-fee basis. But I think most people just do it themselves. You just ask for a review, basically. So you get your decision letter. If it says no, it says this is how you review. Ask for a review, and you can ask for a review of the decision. So there's the checklist stage, which we've discussed. They filter out people who just are not eligible. If you are filtered out, then you can request reconsideration.
Okay.
And if there's a positive outcome to the reconsideration request, you go to a full assessment.
Mm-hmm.
If there is a negative outcome, then you can go to something, you'll be familiar with this acronym, an IRP. You can go to an independent review panel, which is independent of the ICB, who then look at it afresh to decide if you should meet the initial threshold for a full assessment.
Okay.
And if you don't pass the IRP stage, you can go to the Ombudsman and complain.
Okay. And can you judicially review any of those decisions?
Theory.
I imagine, I suppose you can.
The problem you've got with the checklist
your alternative
stage,
remedy, haven't you?
Exactly.
Yeah.
So in theory, you could go all the way to the Ombudsman. You could judicially review the Ombudsman. I mean, I read the admin court law reports, and it's not something you see very often.
But it's the Ombudsman decision. You'd be JRing, isn't it? So it's not the initial ICB decision.
Yeah, exactly. So you then, even if you successfully judicially review the Ombudsman, the outcome is likely to be that the Ombudsman has to reconsider its decision, and they will just potentially make the same decision again.
Yeah, it's almost the process as opposed to the substance,
exactly.
Which is less helpful, I suppose.
Yeah.
So it's probably better to get, all of the information at the review stage in, because that's when you're reviewing the substance as opposed to the process of where you got to at the end.
Yeah, and then once you've got your positive checklist, as it's called, you then go to your full assessment, and again, you can challenge that if it's not granted.
Same process.
Yeah,
same
essentially.
process. Yeah. Okay, it's interesting. It's interesting to know about that, because I think there's a massive gap in parents' knowledge about that, and one of the main reasons that I did want to do this podcast with you, because I know it is your specialist area, and any issues that we have in this area, we will come to you. A lot of the time, obviously, there's other people that do it, but we've got massively good relationships, so we always come to you. But is that cliff edge between child social care, adult social care, and all of the massive implications that and anxiety that brings. So it's good to know that there's something out there that you can do, and it's good to be able to prepare for that.
Yeah, and I think, social care is a whole other issue, right? So if you're not eligible for CHC, then you're probably, you will still be eligible for social care.
Yeah.
So you can ask your local authority to do a social care assessment. They will then assess you and decide if you have an eligible need for care and support.
Mm-hmm.
And if you do, your child does, they will then produce a care and support plan, which it looks nothing like an EHC plan, but it's similar in substance in that it outlines what your needs are, the support that's required to meet them.
Yeah.
And then depending on, as we've discussed, the financial situation, either you will have to contribute to some of your care or the local authority will provide it.
That's different from a child in need plan.
Yeah, so a child in need plan is in relation to children's social care.
Yeah, of course.
So
they're reviewed like quite often, aren't they? Like maybe every 2-3 months or something.
Yeah, and care and support plans can be renewed every year. Or reviewed, not renewed.
Yeah.
They should be and kept up to date. But you can also ask for a renewed assessment. Yeah. So you can have your care and support needs updated if they change.
Yeah. The last question that I want to ask you, Matt, on this topic is the different types of social care assessment.
Yeah.
So can you just kind of break those down? Because sometimes there's like an assessment under Section 17, there's Section 2. So can you just break those down for our parents just so that they understand what kind of assessment's being done?
Yeah, there shouldn't be an assessment under Section 2. But there's a Section 17 assessment, which parents will have heard of when their child is actually a child. Yeah. Because Section 17(10) of the Children Act says that a child with a disability is automatically a child in need. Yeah. So they should have their social care needs assessed. Yeah. There is then, it's sometimes called a parent carers needs assessment or a Section 17ZD assessment, which is a parent carers needs assessment, i.e. you are, as the parent carer of a disabled child, are also entitled to social care support. So they will assess that as well. Similarly, if you have more than one child and only one is disabled, for instance, and the others aren't, then they can also have their care needs assessed because they will probably have care needs. And it might look as simple as something like, well, your other children should get some respite away from the home because of the additional stress they're under because of having to live with a disabled sibling. Yeah, or one-to-one time with their parents. Or one-to-one time with their parents, exactly. When you get to transitioning, you then jump to a different act. So you move from the Children Act 1989 to the Care Act 2014. Sections 58 to 66 govern transition arrangements. So there should be a transition assessment. There's then a transition carers assessment, a whole process that's followed to show what your needs are likely to be as an adult when you transition from children to adult social care. And then once you've transitioned, you have a Care Act assessment under Section 9, which is what assesses your ongoing care and support needs. So they're the main ones. And again, there are carers assessments that can be carried out as well. Yeah. But then some provision, going back to the very beginning, is it under Section 17 that you get some provisions under the Chronically Sick and Disabled Persons Act? Yes. Yeah, so it's a 17 assessment, but you get some provisions under Section 2 of the Chronically Sick and Disabled Persons Act. Yeah. Okay, fine. And we've got a podcast with Gary Crisp anyway that discusses what goes into a social care assessment and what that actually looks like. So anybody can have a listen to that if they want to about the intricacies of that. But I think that's really useful because local authorities do quote it's a Section 17 assessment and it's, for a layperson, it is very difficult and you are filled with fear and dread, right, when someone's saying, we're going to come into your home, we're going to look at how you're taking care of your child, and we're going to make decisions based on that, about what should happen, what shouldn't happen, what's good and what's bad. So it's good for that to be outlined, I think, and I know it's easy for us to say we're sitting in a podcast studio, but it's, I think, maybe taking a step back and looking at the finite of what it is that social care team is coming in to do is useful, and it's probably going to benefit you because it's probably going to give you something that you need. Yeah, and it's important to distinguish between a Section 17 assessment and what we haven't discussed again because it's more family law orientated, the safeguarding assessment. Yes, of course. Which is then what is done before a local authority thinks about issuing care proceedings, but they are different things. Yeah. And there should, in theory, be a separate social work team that deals with it, but... Yeah, of course, because you hear social care and you think someone's going to take my kid away. That's what it's natural. It's just automatic. But it's if we kind of just take a step, and this is why we want to put information like this on the podcast, because if your child is very young and you're listening to the podcast, for example, then at least you've got this information in your arsenal
that when something like that does land on your desk, then you are a little bit calmer, you are more knowledgeable, and you can look at it more pragmatically.
Yeah, and I think the key thing for parents to remember is that actually, yes, there is a lot of fear around local authority social care teams, but actually at their core, they are there to help you.
Yeah.
They are there to offer you support to help meet the additional burden of bringing up a disabled child.
Yeah. I think that's a really fantastic note to end on. So Matt, thank you so much for coming in and speaking to our parents about that. It's been really lovely. Thank you.
Thank you for having me.
Thank you.